Okay, it's 2 o'clock. Thank you for everybody who took the time to show up. I know it's mid-afternoon. I know for a lot of the estate planning attorneys who are present today, our time is pretty valuable right now, a lot of year-end stuff going on. Only to be complicated and added to by this Proposition 19 that's passed, which has caused much scrambling around. Fortunately, we have a little bit of time to do some planning around it. So what I hope to do today is to make everybody aware of the issues and what we're dealing with. I know that many attorneys might already know that, but I do have a lot of clients and prospective clients who aren't lawyers or anything like that. So I'm going to try to keep it pretty basic so that we can all understand the issues and the implications. So I'm totally used to Zoom meetings, and this is the first time I've done a Zoom webinar, and I was really anticipating seeing everybody. And with a webinar, apparently it's not like that. So I'm literally looking into my computer screen at my presentation, and I can't see anybody. But I do have a list of the attendees here, and it's great to see a lot of names. I wish I could see you. I wish this could be a live event, and hopefully in the next several months and maybe by the end of the year, we'll be back to doing those kinds of things. But this is what it is right now. So because I can't see you, there's not really going to be a live interaction of exchanges, but there is a function, I've been told, actually I've been using it, that you can send me question and answer. So there's like a Q&A function on that. And I would highly encourage you to ask me questions in that Q&A function. So there's like 135 registered. So if I get inundated with questions, I don't know if I can answer everybody's question right away, but I will certainly email you and answer them. Also, if you have other questions that arise that I don't get to, feel free to email me, and we could go over that as well. So I'm already getting questions, all right? So I'm not going to let myself get bogged down, at least not now. Maybe we'll save the question and answers for the end, because otherwise I think I'll get a little bit too distracted. Okay, so with that said, let's move on. So as the topic announces, California is increasing residential property taxes. It's actually broader than that. They're increasing property taxes. Perhaps to the voters who voted for this proposition, it's that they're unwittingly, as to the population, raising property taxes, but definitely it will have the effect of raising property taxes. So my agenda today is to go through a brief history of Proposition 19, what Proposition 19 does, and then go through some planning options. There it is, our wonderful California legislature in California. Surprisingly, this Proposition 19 was generated through the legislature. The legislature proposed and passed the Proposition 19 by a pretty significant amount, as you can tell here in the on the screen. So in the Senate by 29-5, in the Assembly 56-5. So there was overwhelming support for Proposition 19, not the least of which the main sponsor behind this Proposition 19 was the California Realtors Association. So they have a pretty strong lobby in Sacramento, and I think, as we can tell by the numbers, they got this proposition through the legislature, and now it became a ballot measure, a proposition on the November ballot, and it passed. It passed 51%. Little over 51% to about little under 49%. Not a great margin, but by today's standards, it's not a bad margin by which to pass. And I think the reason why it passed is a couple reasons. First of all, I think everybody was consumed with Proposition 15, which was the other property tax measure on the ballot, which sought to increase commercial property taxes. And so everybody was fighting against that, and they kind of let this Proposition 19 go unnoticed. The second reason why I think it passed is if you read the ballot, right, you think it's pretty innocuous, right? Allows homeowners over 55, disabled, or wildfire disaster victims to transfer their primary residence tax base to a replacement residence. Wow, that sounds pretty good. Okay, I could go for that. It changes taxation of family property transfers. So you see how innocuous that is? Doesn't say that the changes are likely to increase property taxes for family property transfers, just says that it changes it. And then, of course, it establishes a fire protection service fund. And with all the fires that we've had over the last several years, that's really good news. So I think as a result of the way it was written, coupled with Proposition 15, this ballot measure passed. And it has pretty significant consequences. I can tell you, as an estate planner, I do family property transfers a lot, and I rely on the ability to prevent reassessment on those family property transfers a lot. I rarely do, and rarely have I seen, but I've seen situations for 55-year-old people and older who sell their property and now move into another property, and they get to roll over their tax base. If I just looked at my practice, my situation, that which I know, and I do a lot of property taxes, that's rarely an issue. You just don't see that happen that often. It did expand this provision, and that's not by the way, that's not the purpose of this webinar today. And I'm not going to talk, other than what I'm talking about now, I'm not going to talk about that provision of Proposition 19. But suffice it to say that I don't think personally that that provision has that great of an impact. And yet it was the first thing mentioned in the ballot. So the big thing that had the changes was the family property tax transfers. So what does it do, right, with respect to the family property transfers? So before Proposition 19, so right now, all right, as we sit here today, all right, we have Proposition 58, which says that transfers between parent and child are excluded from reassessment. They actually hold in the statute, if you want to be technical, that a transfer between a parent and child is not a change of ownership. But you can think of it as just an exclusion from reassessment. And there were two primary requirements. So one, if it was your primary residence, a transfer of your primary residence from parent to child, and by the way, it does go vice versa, but I'm just going to keep it easy, just parent to child, are not subject to any dollar limitations or other restrictions. So you have a primary residence, you can give it to your child, it could be worth $20 million, it can be somewhere in Silicon Valley and have a huge value, and you can give it to your child, and there's not going to be a property tax reassessment on that, provided that it's your primary residence. Your child doesn't have to live there. Your child can rent the property out. Your child can use it as a vacation home. Doesn't matter. There's no restrictions on that. The second level of parent-child exclusions are transfers of property other than primary residences. And with respect to those, a parent could transfer property other than the primary residence to a child and not be reassessed to the extent that the assessed value of the property is $1 million or less. There's a lot of property out there, believe it or not, a lot of property out there whose assessed value is less than $1 million. Couple that with a married couple who has community property, you're talking $2 million. There's an extreme amount of planning that an estate planner or other attorneys can do with respect to this exclusion. Basically, it allows us in many instances to make gifts and do our estate planning things with respect to parent and child and not be reassessed on those transfers. After Proposition 19. So first of all, Proposition 19 is effective February 16, 2021. So if anything's going to be done, it should be done and recorded and put to bed by February 15th, 2021, if not before. But what it does is it pretty effectively eliminates or substantially restricts the parent-child exclusion from reassessment. So with respect to primary residences, so a parent-child can transfer a primary residence to a child and it won't be subject to reassessment if, and this is a big if, the child to whom it's transferred lives in the primary residence as his or her primary residence. So that happens. I'll grant that. It doesn't happen that often, but that does happen. There's also another restriction on there is to the extent the fair market value of the property that's being transferred to the child exceeds $1 million of the assessed value, or the amount above the $1 million is subject to reassessment. So there you go. That's your parent-child exclusion. The other one, the $2 million assessed value exception, that's gone. That's all you get right here. Primary residence, and your child has to reside in the property as his or her primary residence. That is pretty significant. I know there's a lot of estate planners who are attending. I mean, just ask yourselves, I mean, how often are you transferring between parent and children as part of your just basic estate planning? And you're relying on there being no reassessment on those properties. A lot, at least for me. At least for me. So this is going to have significant consequences. So who this affects most? Well, obviously it affects the estate planner. What are we going to do? You know, we've created a lot of these qualified personal residence trusts. They don't qualify. They don't qualify for the parent-child exclusion. To the extent you have one now, you might want to go to your estate planning attorney and see if you can decant it or modify it in some way so that your children get the present benefit of that QPERT, particularly if you have a number of years left on it. If you own commercial property and you're intending to give that to your kids and you have a pretty low assessed value, same thing with a residence or a beach home, vacation homes, things like that. Where you have a low base year value and it's been in the family for a while and there's little likelihood of the property being sold. These are the people who are going to be affected. So what are some planning opportunities? And these planning opportunities that I'm talking about, or that I'm going to go through, are planning opportunities primarily between now and February 15th. All right? And these are some ideas that I've developed. These are some ideas that I've discussed with others, but I can tell you, no one's really sure, right? No one's really sure about anything that that this proposition is going to entail. We don't know how the assessor's offices are going to react. I mean, we did things as estate planners. We transfer property into trusts that where the children are the beneficiaries of. Never think twice about whether the assessor is going to not recognize that transfer as a change of ownership. Now you have to start thinking about that. Well, if the parent retains certain levels of control over that trust, is it really a transfer? Is it a change of ownership within the property tax rules? So we're all kind of thinking about these things that we didn't necessarily think about or we took for granted prior to this. Because the assessor's office would always want there to be a change of ownership. Now it's kind of flipped, right? So one easy, straightforward possibility, and don't discount this, all right? Don't discount this at all. I have a client right now who's actually going to be doing this. Gift property directly to a child. Absolutely, you can do that between now and February 15th. It will qualify for the parent-child exclusion, assuming that the assessed value is less than $1 million, or if it's community property, $2 million, or if it's a primary residence. Okay, here's the big stickler is, okay, when you die, your child's not going to receive a step up in basis in the property. So what that means is that if you had waited to give the property to your child when you passed away, your child would get a new basis in the property, in addition to the property, in addition to the parent-child exclusion. So unless you're intending to die between now and February 15th, there's not going to be a step up in basis on a transaction like this. And that could be a big disqualifier. You really need to do an analysis on that. You know, is it worth more to pay higher property taxes if and when the property is transferred to your child? Or is it going to cost you more for your child to pay a capital gains tax on that? So you have to just do an analysis. You have to look at what your basis is. You have to look at the assessed value. I think you should consider things. How long is this property really going to be held in the family? Is it a family jewel? Is it going to stay in the property? Do the kids intend to keep it? A number of factors like that should go into this, because virtually, not all, I do have some theories about how we can get some step up in basis. But there's a good chance that whatever you do, there may not be a step up in basis. So I don't know if you know, but you can sell the property directly to your child and still qualify for the parent-child exclusion. So you can sell the property to your child for its fair market value, and the child can still get the transferred assessed value on the property. So you could sell the property and it would qualify for the parent-child exclusion. The parent would recognize gain. Right? That may be a big disqualifier right there. Right? You might just stop right in your tracks. Although you could structure the sale on an installment basis. It is an intra-family installment basis. There's some limitations on that, but nothing too significant that you can't get over. And then just recognize gain as installment payments are made. And the child would get a step up in basis, would get a basis adjustment based upon the purchase price. So that's one way to get a step up in basis. You can sell the child. Now, I have a client, right? And there's a lot of parents out there who don't want to give their property to their children and would consider selling it to them as part of an equalization scheme with their other children, or there may be, you know, gift issues. They don't want their kids getting things. They want them to earn it. So there's different reasons. And I have actually a situation like that right now with some property up in Watsonville. So that's a second possibility. You're going to get the parent-child exclusion. So you can also gift property to a grantor's trust, an IDGIT that stands for Intentionally Defective Grantor's Trust. So for those of you who don't know, and I don't want to get too technical on this, but a grantor's trust is a trust that's not recognized for income tax purposes. Because for some reason, some power that you, the grantor, retain over the trust is sufficient that the IRS considers that trust to be you for income tax purposes. So look at a classic grantor's trust is your revocable living trust. You retain the right to revoke that trust. It's a grantor's trust. Right? The type of trust I'm talking about, and when I say an IDGIT, I'm referring to an irrevocable grantor's trust. All right. So a trust, you're transferring it to a trust that's irrevocable. It's not your living trust. So even though this trust is irrevocable, you can still, as the grantor, retain certain powers over that trust to have it be considered for income tax purposes, disregarded as if it doesn't exist. So that's what a grantor's trust is. So one possibility is you could give the property to an intentionally defective grantor trust, of which your children are the present beneficiaries, that absolutely qualifies for the parent-child exclusion, right? If your children are the present beneficiaries of the trust, in property tax law, the assessor's office looks to the present beneficiaries of the trust. It's as if the trust doesn't exist. That's how they determine who qualifies for the parent-child exclusion. So what's good about the intentionally defective grantor trust is, okay, you're giving your property now to your kids. A lot of parents don't want to give their properties now to their kids. And if they can give it to them in a trust where they get to retain control, or where there are controls over what the children can or can't do with the properties, maybe having a trustee, an independent trustee, or even a family member as a trustee, that could be a kicker for many parents who may not otherwise be willing to give their property to outright to their children. The other thing is you put it into an intentionally defective grantor trust. The assets, there's a strong position that the assets in that grantor's trust is protected from your child's creditors. And I mean that in the broad sense. So that means judgment creditors, possibly tax authorities, ex-spouses, things like that. So if you're considering giving to your children, but you just don't think they're old enough or wise enough or responsible enough, you could give it to them now, qualify for the parent-child exclusion, and still retain some control over it. Okay, it's not, because the trust is you, right? You're making a completed gift. So the IDGIT would not qualify for a step up in basis when you pass away. But we do this all the time, by the way, as estate planners, right? We always look at, is it better to get step up in basis, or is it better to have assets removed from the estate and not be subject to estate taxes? Well, in the estate tax realm, usually avoiding the estate tax takes precedent over avoiding a capital gains tax. We'll we'll pay the capital gains tax if we can keep it out of a taxable estate, because the taxable estate is higher. I don't think that same analysis would be true when you're looking at foregoing a capital gain or paying a capital gain or paying higher property taxes. I mean, if you have $1 million property, you're paying $10,000 a year in taxes on it. If you have $3 million property, you're paying $30,000 a year in property taxes on it. It's a $20,000 difference. If you sold that property for $3 million, there's a $2 million gain, let's say the basis was $1 million. So $2 million times, add California tax in there, so just say 30%, that's a $600,000 tax. That's a lot of years to be saving $20,000 a year in taxes. So in that case, you very well might just say, I'll wait to get the step up in basis. But again, every situation is different. You need to look at all the facts and circumstances on the ground. Is the property going to be sold? Is it going to be kept? If the property is going to be kept, and you're pretty sure about that, you don't care if it's about the property tax basis, about the capital gains tax, maybe. And it might hurt you more to be paying that extra $20,000, $30,000 a year over the next 20, 30 years, over several generations, or at least a generation of children. You have to do the analysis on that. Similarly, you can sell property to an IDGIT. So just like you could gift it, you can sell it, right? So you might have some income producing property that has an assessed value, it's community property less than $2 million. You can sell it to the IDGIT and still qualify for the parent-child exclusion, all right? Because the children are still the present beneficiaries of that IDGIT. You still retain control. You got your asset protection considerations. Now, remember what I said, the IDGIT is disregarded for income tax purposes. So if you sell it, and that means the IDGIT has to pay you back money, either you do a lump sum, but most people will do a promissory note, ensuring a stream of income to the parent from that grantor's trust, from that IDGIT. There's no tax on that transfer because you're selling it to yourself from an income tax point of view. So you can sell it to the IDGIT. You get a nice income stream back for the life of that note. And it's non-taxable. Now, okay, there's some other considerations here, because of course, if that property is income producing, and remember the IDGIT's getting that income, although a good portion of it is coming back to you in the form of this promissory note. But that income that's generated by the IDGIT, it's reported on your income tax return, even though you're, other than the payments on the promissory note, you're not getting that income. And yet you're paying the income tax on it because it's disregarded. So you have to run the numbers. Just like in the gift transaction, the IDGIT does not qualify for a step up in basis. But I have a couple ideas on that. Maybe some estate planning attorneys will send me some emails or some questions on some of my thoughts. Look, you can gift property to an IDGIT or sell property to an IDGIT, and you can lease it back. I mean, you could do this with a home, for example, your primary residence. So you could give the home to the IDGIT, qualifies for the parent-child exclusion. You've got your control, you've got your asset protection, but now the parent leases the property back from the IDGIT, right? So in other words, the parent pays rent to live in their home. I know you got to overcome that. You got to conceptually, mentally get over that. You're paying rent to live in the home that you've lived in the last 20 years. But you're paying home to this IDGIT. And because that IDGIT is considered to be you, that rent that you're paying the IDGIT is not taxable rent. So, so you're not creating any kind of income tax situation. I like to call this situation the gift that keeps on giving, because you're making the gift of the house to the IDGIT, you're living in there. Now you're paying fair market value rent every year, every month, whatever the terms of the lease are going to be. You pay the rent to the IDGIT, and those rent payments are now going from your taxable estate to your non-taxable estate, without using any of your gift tax or estate tax exemption, without using your $15,000 a year annual exclusions. So those rent payments are like continued gifts to your children, and they can accumulate, and the trustee of the trust can invest those rent payments in assets, and hopefully have the trust grow, because all the growth is outside of the estate, of the taxable estate. All right, no step up in basis. All right, we're not there yet. So Proposition 19 only affected, well, the 55-year-old and older, it affected that. But other than that, it only affected parent-child exclusions. It did nothing with respect to transfers to legal entities and the transfer of interest in legal entities. And that gives us, and still will give us, a lot of planning opportunities. One of those planning opportunities is you can transfer at least 50% of your interest in property to an IDGIT and create an LLC. So you and the IDGIT create an LLC, and you each own 50%. So the transfer to the IDGIT qualifies for the parent-child exclusion. And now the IDGIT and you transfer your 50% interest to the LLC in exchange for 50% interest in the LLC. There's no change of ownership there, because you're just changing the form of title. You're not changing the proportionate interest. So we qualify for the parent-child exclusion. We qualify for the transfer of interest. On the parent's death, their 50% interest passed to the IDGIT or to another beneficiary. There will be no reassessment, since no more than 50% interest in the LLC were transferred and no child obtained control. All right, there's a caveat here. You have to have at least 2 children. If you have 1 child, I don't think it works, because now the 1 child is getting 100% of the LLC, and that's control, and that would trigger a reassessment now of the whole property, or at least, yes, of the whole property. But if you had 2 children or more, and now that 50% interest passes to the IDGIT, the 50% interest of the parents passes to the IDGIT on their death, there's no reassessment, because not more than 50% was transferred. And no one has control. Not 1 child of the 2 or more children have control of the property. So this is one way that we can keep the parent-child exclusion going, at least through the parent's death. And I think we should be able to get a step up in basis on at least 50% of the property, because the parent still has 50% of the LLC in their estate when they pass away. So that LLC is included in their estate, they get a step up in basis. So no reassessment and 50% step up in basis. That's not bad. I mean, again, you got to run the numbers, you got to apply it to every client situation. But that's a good possibility. And that's just playing around with the parent-child exclusion and the transfer of legal interest exception. So we're kind of bootstrapping, we're using two exemptions or exclusions from reassessment, and that works out pretty good. You could just transfer a property to an LLC and gift or sell 50% of the interest to an IDGIT. I do this sometimes. So the parent has 100% of the property. They transfer their property to an LLC. There's no reassessment on that property, all right, because it's just a change in form. We're not using the parent-child exclusion or anything like that. We're just using the legal interest exclusion. Now if we transfer no more than 50% interest in that LLC to the IDGIT, there won't be a reassessment there. So at least we're getting 50% of the value of the estate out of the trust, out of the estate, without incurring a property tax reassessment. Now, when the parent passes away, and by the way, I'm assuming here I'm using plural, parents, right? So the parents own the 50%. When the first parent dies, the surviving parent gets the 50% interest. There's no reassessment on that. There's a spousal exclusion with respect to LLC interests. Doesn't apply. LLC interest, these legal entity interests, do not apply to parent-child. So you can't give a legal interest to a child and say, hey, I'm going to claim the parent-child exclusion on that. Can't do that. But you can do that with a spouse. So even when the first spouse dies, there's no reassessment. Survivor gets the balance of the 50%. And now the 50% passes on the survivor's death to the intentionally defective grantor trust. And there's probably going to be a reassessment on that event. So you got 50% out of the estate, and it's not going to be subject to estate taxes. But there'll be a reassessment when the parent passes away. And you should get a step up in basis on 50% of the property, I think. And by the way, so this one example I've used, this can be done even after February 15th, all right? So there's no rush to go and set up something like this. This can be done well after that, because you're not using the parent-child exclusion at all with respect to this idea. All right, some basis adjustment strategies. All right, well, I've talked about one. You could do an installment sale. All right, it's not a great one, but it's possible. All right, could fit into a particular situation. We have the 50% transfer of an LLC interest to 2 or more children, or to an IDGIT, or to a non-grantor trust where the children are the beneficiaries. So that's a possibility. You get a 50% step up in basis. So there's this other concept. So now I'm talking about federal estate tax law. All right. So how do we get the LLC? How do we get the property or the LLC? How do we get it into the parent's estate? Assuming we're not dealing with estate tax issues, we don't care about estate tax issues. We just got normal mom and dad, and their estate's worth $5 million, and they don't care about the estate tax because they're likely not going to be subject to any estate taxes anyway. So how could we set up one of these and still get step up in basis? Well, there's a provision in the Internal Revenue Code that says if you retain certain rights to possession and enjoyment of the property, or to the income of the trust, or you retain the right to designate the possession and enjoyment of the property or the income, that if you retain those kinds of powers over the trust, that the assets will be included in your taxable estate, even though you made a completed gift to an irrevocable trust. So you can try to structure your IDGIT to where, and this is kind of anathema to estate planners, right? Because we do everything to try to keep it out of the estate. Now we're trying to do everything to put it back into the estate, right? So actually we're on the same page as the IRS, because the IRS tends to always try to get it back into the estate. And these are the provisions that they rely on. So now you can just follow some of the cases that the IRS has fought so diligently on, holding where, for example, if you do a sale to an IDGIT, remember it's a non-taxable event, it's out of your estate for estate purposes, you get a promissory note back. Well, I can tell you there's a number of cases out there where if that promissory note, if you didn't put any seed money into the trust, or if that note just happens to equal or really come close to the amount of income that's generated by the property in the trust, the IRS has held time after time, and the tax courts have approved their position on these. The IRS has held that that's a retained income interest. Okay, you might have structured it so that you got a promissory note, it looks like a sale, smells like a sale, but it's not a sale, right? It's really a retained income interest in it. So you could structure your IDGIT like that, and now you're making a reverse argument to the IRS saying, oh, this property is in my estate because I had a retained interest. The IRS loves this position. Use it all the time. I mean, this is the one thing that estate planning attorneys are fighting over all the time. And now we're just putting it back into the IRS's face and saying, you know what, you're right. I retained this interest in it, included in my estate. I think for California property tax purposes, it's my opinion, I cited the rule here, this comes right out of the assessor's handbook. A change of ownership occurs when there is a transfer of a present interest in real property, including the beneficial use thereof, the value of which is substantially equal to the value of the fee interest. If I transfer my property into the IDGIT, and if I have a promissory note that's paying me back money that comes pretty close to the income, I've still transferred, for property tax purposes, for California property, I've transferred a present interest in that real property. That trust owns the property, and there's present beneficiaries, namely my children. And they're entitled to the income, they're entitled to the appreciation. I mean, I've just never even seen an assessor's office try to take a position otherwise. So, I mean, matter of fact, we never even consider it, because we always consider the assessor's office is going to recognize this as a change of ownership. Whether they do between now and February 15th, okay, remains to be seen. Are they going to, take an aggressive approach on this? Because really, this is only going to apply to transfers between now and February 15th. I'm not sure. But I feel pretty confident in that. I mean, I'm curious to know what other estate planning attorneys think about that. But I think it's a transfer for property tax purposes. It'll be recognized, even though it will be included in the parent's taxable estate when the parents pass away. And maybe I didn't mention, but why do we want it included in their taxable estate? So we can get a basis step up in the property. So your kids can get a basis step up in the property. So if we can get it included in your estate, your kids are going to get a basis step up, and they're still going to retain the parent-child exclusion, the low property tax base. Another possibility I have is, look, you can have the parents act as trustee, maybe put some provisions in the IDGIT that, allows them to do some self-dealing and maybe vitiate some fiduciary duties and things like that. The IRS doesn't like parents transferring property to a trust that ostensibly makes the property not included in the parent's taxable estate, and the parent's still the trustee of the trust. I mean, for those of you who are my clients and we've done these IDGITs before, I mean, how many times have we worked it to where we have somebody else be the trustee of the trust? Maybe your kids, right? Maybe a sibling, right? Maybe an independent trustee. But if you act as trustee, that could be considered a retention of ownership, that look at, you really retained ownership, incidences of ownership, control. You never really relinquished possession and enjoyment of the property. I think from a California property tax point of view, for the same reasons I just gave, I think that it's still a change of ownership. I can be the trustee of my own trust. I mean, that happens frequently anyway. And it can still be a completed gift for property tax purposes. My children are the present interest beneficiaries. They're entitled to all the appreciation. Okay, I'm the trustee, but it's subject to my duties to the beneficiaries. So those are several basis adjustment strategies that I have. There's probably more that we're not thinking about. This provision in the Internal Revenue Code is pretty broad about retaining certain rights to possession and enjoyment. I mean, one of them, which is not going to work, all right, is one right that you can retain that would bring it back into your state is the right to change beneficiaries. All right, that would bring it back into your state for sure. But I don't think if you can change the beneficiaries to a group other than your children, then it's probably from a property tax point of view, they're probably not going to consider the children as the present beneficiaries because you retain the right to change that class of beneficiaries. Now, maybe if you could only change people within the class, maybe that would be acceptable. Also, another thing that people have been trying to work into this mix is maybe somehow giving the parent a general power to appoint the assets in the trust, either inter vivos during their life or on their death. That would likely, if the assessor's office was even aware enough to look for something like that, and I wouldn't put it past them, so I wouldn't count on this, but if they were to look for a provision like that, it would probably hold that it's not a change of ownership for tax purposes, because if you have that general power, you really haven't made a gift to your children as present beneficiaries. So that's what I think about that. And of course, having those powers would be sufficient powers to bring the assets into your state to get a step up in basis, but they probably wouldn't work for property tax purposes. So that's my presentation. Why don't we go to some questions and answers? Oh, I've got a whole bunch. So here's some stuff right off the I'm getting some funny ones too, so I'm going to try to bypass those. All right. So it's a good question. Is recording a transfer necessary prior to 216? Or can we rely on California law that a transfer is effective when signed and delivered? If you notice on the preliminary change of ownership report that has to be filed with every deed that's recorded, there's a box, it's right at the top of the second page, at least on most of the forms, that says, is the recording date a date, is the transfer date other than the recording date? So definitely check that box and put the transfer date, which would be the date prior to February 16th. I think California law would stump any assessor's rule that, oh, it has to be recorded to be recognized as a transfer. Heck, even the PCOR has that box that lets you indicate that the transfer date is something other than the recording date. Is it too dangerous? Well, okay, I don't know if I would want to try it. If I had to rely on it, I would. It certainly would be better to get everything recorded prior to February 16th. With COVID, the recorder's office isn't fast. They've gotten better over the last few weeks, but now we have the second wave. Yeah, I feel pretty comfortable relying on it, but I wouldn't want to rely on it. Would gift tax apply if property was given to a child? Absolutely. You're making a gift, a completed gift. So that would be whether you give to the child directly or whether, or whether you give it to an IDGIT, you're making a completed gift. And whenever you make a completed gift, you're making a gift subject to gift tax. You would either apply your annual exclusion to a portion of that, and then your remaining lifetime exemption. Would a self-canceling note work for a sale to a child? Absolutely. The benefit there is, the assessor's office isn't going to care, at least I can't think of a reason standing here today, why they would care whether it's a promissory note or a self-canceling promissory note. A self-canceling promissory note, by the way, is a note, the balance of which on your death is canceled. You don't owe anything to the estate of the decedent, it's canceled. So there's certain rules that have to be respected with respect to those. You either have to charge a premium on your interest rate, or you got to add a premium to the principal. So there's some rules. You have to have a doctor's certification that you're not going to die within a year. So there's stuff like that. But otherwise, it shouldn't matter from a property tax point of view. So any of those examples that I gave where you're selling to an IDGIT, and if you're using a self-canceling note or just a regular promissory note, I think the same principles would apply. Would the parent still be the trustee and could sell the property and use the principal for his or her living expenses? Well, as I said, I think the parent can be the trustee. You're risking estate tax inclusion by doing that. And that might be what you want, right? So you want to risk that. Matter of fact, you not only risk it, you might even want to be arguing that. And if that's the case, in order to get the step up in basis. So if that's the case, the parent can absolutely be the trustee. If estate tax is an issue, I would refrain from having the parent be the trustee. But as trustee, yes, they could sell the property. Could they use the principal for his or her living expenses? No, because now they would be a present beneficiary of the trust, and that would destroy the parent-child exclusion. So you can't make it a self-settled trust, first of all. A self-settled trust being a trust that's created by the grantor for the benefit of himself or herself, even if it's for others. California doesn't like those. And if you are a principal or income beneficiary of the trust, that would probably negate the parent-child exclusion, because they want all the kids have to be the present beneficiaries. You can't have someone other than the children also be present beneficiaries of a trust in order to qualify for the parent-child exclusion. Well, I got a long question here. And by the way, how much time do we have? I got 2:47. I'm going to go till 3 o'clock. To the extent I don't answer any questions or my answers raise further questions, feel free to email me. My email is right there. All right, so you can do that. How long might an assessor claim that a child must reside in a parent's former residence before in order to claim this new parent-child exclusion? I have no idea, and I don't think anybody does. I think there's going to have to there perhaps has to be some legislation in order to clarify some of these provisions here in this Prop 19. Maybe some regulations issued by what are they called now? The California Tax and Fee Administration, or the former State Board of Equalization. The assessor's office might have to come out with some rules and regulations, to the extent they even have the authority to do that. I don't know. But otherwise, I think that's an open question. It's a fair question, but I think it's an open question. So the example would be, what if your child only lives there a year and then moves away? Well, maybe it would be reassessed when they moved away, when it was no longer their primary residence. Certainly, if they sell the property, it's going to be reassessed, so there's no issue there. So I don't know. I believe that in order to qualify for the parent-child exclusion, a real property gift by a parent to a child needs to be in a form which would otherwise constitute a change of ownership. Let us call that a completed Proposition 13 gift. Can you perhaps suggest which form might such a completed Proposition 13 gift take, such that it would nonetheless be subject to being called back into the gross estate of the parent? So I think I answered that. I think with respect to some of those examples where we're making a completed gift for property tax purposes, at least what I believe, but you make the parent the trustee, maybe reduce some fiduciary duties to the extent you can under California law, and then have these retention rights if you sell the property, have these retention rights to possession and enjoyment and income over the trust. So here's a good question. If a parent owns non-primary residence in which the child lives, he should transfer the ownership prior to 2/15/21. So how about this for a lawyer's answer? Not necessarily. Right? You need to do the analysis for the reasons that I talked about. You've got competing interests with respect to step up in basis and competing interests with respect to property tax reassessment. And then you can even throw in the competing interests of estate tax inclusion. So now, at least for the next 60 days or so, we've got three things to really kind of consider in the mix here. So I wouldn't just say, no, absolutely, you should go and transfer. I think you need to do an analysis. And the analysis would be of the, if it's not your primary residence, the analysis needs to be of the assessed values, of what properties are likely to be kept, if any. Are the children going to keep any? Are the children young? Are they old? What are the goals? So are most other states already operating as we are going to have when this proposition goes into effect? Well, California was pretty much alone. I mean, everybody has their own little property tax rules and ways to keep property taxes down and so forth. But California, as far as I know, was the only one who really strictly limited its property tax base to what we call acquisition value. And not fair market value. California, you buy property, that becomes your property tax base for the remainder of the time you own it, and do not change ownership. Subject, of course, to the 2% trending increase that we all get every year. But otherwise, it's based on your purchase price. Most other states base property taxes on fair market value. And they do that, if not on an annual basis, on a regular basis. They're reassessing their property to fair market value. And that's exactly what Proposition 13 limited. And now we're being further limited in the parent-child exclusion by now having transfers between parent and children to be included as a change of ownership. So if sold to child, does property have to be child's primary? Yes. So the assessor's office, the law doesn't require whether it's gifted or sold. I don't even think they really care from a property tax point of view. To qualify for the parent-child exclusion, it has to be under the new law, it has to be a primary residence. Now, they may want to look at, what the price that was being paid. You might have it be $950,000 and the assessed value is only $50,000, and you're trying to get under that $1 million reassessment exclusion. So maybe in that situation, they may want to look at whether it's an arm's length fair market value price. But other than that, I don't think they care. Yeah, so what if you have more than one child? What is the impact of giving your home to 3 children? That's another unknown. So let's say you do give your primary residence to 3 children and one lives in the residence as their primary residence. Is the property going to be fully reassessed? Is only 1/3 going to be reassessed? I mean, 2/3 going to be reassessed? I don't know. I really don't know. I don't think, if anybody else knows or has ideas, let me know. I don't think we have the answer to that question yet. I think it'll come down the road. Regarding capital gains tax versus estate tax, don't we expect that will change under the new administration? So yes, I mean, that's what's making estate planners, attorneys crazy now. I mean, particularly before the election, right? We were touting the possibility of a new administration and new estate tax laws potentially being effective retroactively to January 1st, 2021. My thinking now is, even though we have a new administration, it wasn't the complete change of Congress like some people were anticipating. While I do think that there's still a fair chance that estate taxes or the estate tax exemption will be reduced as early as mid to late this year in 2021, I don't see it in a pandemic, with the political situation in Washington, assuming you were to even get a compromise along that level, I don't see it being retroactive to January 1st, 2021. So maybe it'll be effective when it's enacted. Maybe it'll be effective January 1st, 2022, something like that. So I know that we're still, I mean, at least I'm still completing all of the estate plans that we were urging for our clients prior to the election. And I still think that's a good idea. And thus you still need to weigh then property taxes and estate taxes. I think when you weigh property taxes versus estate taxes, unless there is some significant reason, estate tax is always going to prevail. The interest of estate tax would always prevail. There might be some anomalies to that, but the estate tax is just too large, and you would have to own the property for a long, long, long time in order to save what you would now have to pay in estate taxes. So that's what I think about that. You know, this is a good question. If I need 2 children, because I only have 1, can I adopt 1? So that now I can give, so now that I have 2 children for that one scheme that I proposed. So I'm actually a professor at Glendale University College of Law. And we had this very issue in some of the cases last quarter, where, you know, before you had, same-sex marriages were allowed, you had, instead of getting married, they would adopt each other, or one would adopt one. And that would give them certain rights and certain inheritance rights. And those are respected by far and large. So I think if you were to adopt a child, that child's an adopted child. It's a legally adopted child. And yeah, okay. Now you can go and do your exclusion. I don't know if you would want to adopt a child for that sole reason, though. But yes, if you wanted to qualify for parent-child exclusion, adopted children are absolutely qualified for the parent-child exclusion. All right, here in the government benefits area, we put the parent's home in an irrevocable grantor's trust, so that's like an IDGIT. But the parent retains a limited power of appointment for step-up purposes. How does this work with reassessment issues? Well, if that limited power of appointment gives the parent the power to appoint the assets to a class other than the children, then I don't think it's going to qualify for the parent-child exclusion. I'd have to give that some more thought, and to the writer, I will give that some thought, and I'll answer you directly. But that's my initial thinking. I know many of these irrevocable grantor trusts that are set up for government benefits are special needs type trusts. So it's not like you're going to expand your base of beneficiaries beyond a special needs type beneficiary, a special needs type child. I imagine there must be some reason for having the limited power of appointment in there. Well, you say for step-up purposes. I don't understand how that would give step-up purposes if it's only a limited power of appointment. Well, we can have a discussion offline, but my thinking is if there's a power of appointment, parent can appoint the asset away from the children, then you're not going to have a parent-child exclusion apply. Some of the same questions. Okay, if for trust admin or probate purposes, if a parent passes away before 216 and child applies for exclusion after 216, do they still qualify for the exclusion? Absolutely, 100% yes. The date of death is the change of ownership date. So if the parent, God forbid, were to die on February 15th, and you file your parent-child exclusion, because you have 3 years, more or less, to file it. If you file your parent-child exclusion 3 years later, and you do the trust admin, and you don't even transfer the property for 3 years, or even beyond that, it relates back to the date of death. That's the change of ownership date. So you would still apply. That was a good question. It was a good question because I was able to answer it directly. How's that? Must you do an IDGIT? No. You can do on some of those examples, you can put a non-grantor's trust in there. The problem with the non-grantor's trust is, or not the problem, but the limitations or the restrictions that you have to consider when you're using a non-grantor's trust is the non-grantor's trust is not you. It's a taxable entity. So you sell the property to the non-grantor's trust, now there's going to be gain, right? Now, you don't get that benefit of it being a grantor's trust. You pay rent to the non-grantor's trust, that non-grantor's trust is going to have taxable rent. So yes, you can use trust other than idiots. And some of those examples, like I said, I did use or talk about even using a non-grantor trust. Is the new administration likely to eliminate adjusted basis on death? I think that is a near impossibility. I'm curious what other people might think, what other estate planners might think. I don't see that happening. There was a lot of talk back in the 2012, 2013, when the estate tax was really being revamped by the Obama administration. And there was a lot of push towards having eliminate step up in basis. And even then, it didn't make it. And to think that it would even have a chance in this environment, I don't think so. But I've been wrong before. Yeah, what happens if the property is worth more than $1 million greater than the assessed value? Is there any loss of the $1 million exclusion? So I think what that question's asking is, if the property has a fair market value greater than $1 million, more than $1 million of assessed value, what happens to that? Well, the amount above the $1 million gets reassessed. So the assessed value plus the amount above $1 million gets assessed. That's how I read it. All right, this is a good question. If the deadline to make these changes has to be completed by February 15th, because it's effective February 16th, by when should people get in touch with you? That's a real excellent question. I know that we're all pretty busy right now with year-end stuff. So I don't know how much is really going to be done before the year end, or at least with respect to the people that we're servicing right now, we're probably doing some of this planning right now. But I anticipate that the load's going to lighten up right after the new year. So I think and I've already talked to several of my clients and scheduled appointments with them to come in the first week of January, the first couple weeks of January. I think that's more than ample time to do the planning and to implementation on or before February 15th. Understanding that ideally we want to get the documents recorded before the 16th, although I think a strong argument, I don't think that's an issue. I really, if it gets recorded after February 16th, as long as it's signed and delivered prior to February 16th, I think it's okay. So yeah, I would say, the first couple weeks, early to mid January, you should be safe. Thereafter, I think clients would be cutting it. What would the effect of adding a child as a joint tenant before 216? So you can add anybody as a joint tenant before or after February 16th. There's no reassessment on that. There's no reassessment on adding somebody as a joint tenant to your property. Now, when you die, and now that joint tenant gets the property by right of survivorship, there's a reassessment there. And if that joint tenant, that surviving joint tenant is your child, there will be a reassessment and there won't be a parent-child exclusion unless the primary residence exception applies. So yes, you can add your child as a joint tenant after February 16th and there won't be a reassessment, but that has nothing to do with that. That has to do with the joint tenancy reassessment rules. So that's all the questions. Thank you for your attention. It went just a little over an hour and 5 minutes. I hope everybody enjoyed it. Again, please feel free to email me with any questions or any comments that you might have to some of the opinions that I might have stated. If you have other ideas or other opinions, I am totally open to listening to them. Okay, so I'm going to sign off if I can figure that out. And I appreciate everyone's time.